All right, so this is the video presentation of the criminal law final paper. Um, just going to kind of summarize things. I don't want to read the entirety of everything word for word. So, first part, compare and contrast civil and criminal proceedings. The big difference is who presides over it. In civil cases, you have the judge proceeding over the entire case. They hear the sides. Usually in civil cases, there's not necessarily lawyers involved, especially in small claims court. But you've got the judge presiding over everything, making the determination, hearing the evidence, and rendering verdict. Whereas in a criminal case, you have the judge and the jury and both sides presenting their cases. Guilt or innocence is determined by the jury, and then the judge renders sentencing. Um, just because you are not guilty criminally does not mean you are not guilty civilly. And I think the greatest case that comes to mind to exemplify that is the O.J. Simpson trial. He was acquitted of criminal trial, but he was found guilty civilly. $25 million to Nicole Brown Simpson's family and $8.5 million to the family of Ron Gold. We got identify the difference between procedural and substantive due process. As far as those are concerned, just because they both have due process doesn't necessarily mean that they are the same. Procedural due process has to do with limitations, how matters are enforced, implied. Substantive due process, on the other hand, has more to do with preventing the government from infringing on constitutional rights or liberties. Procedural due process has to do with how a case is handled leading up to, 1, 2, 3, 4, 5, 6, the order in which things are done. The legacy of English common law and its relationship to modern jurisprudence. Now, we've discussed this before, both in essay form and in our group discussions. English common law is where we got our start. English common law was presided over by a local judge, magistrate, what have you, and they did what was best for the common good of the surrounding area, and they basically relied on precedent. They relied on, well, we've had this happen before, this is what we did about it last time, we'll go from there. As time has evolved, we've become much more based in statutes. There are rules, this is what you can and can't do. There is a threshold of sentencing for violating those terms, and dependent upon the severity of your crime, you go on the lower end or the higher end of them. Discuss the implications of constitutional, case, and statute law and the relationship to the criminal justice system. Constitutional law, Constitution's in the name. It came into effect after our Constitution was ratified. Constitutional law is defined as the body of law that evolves from a constitution, setting out the fundamental principles according to which a state is governed and defining the relationship between the various branches of government within the state. Basically, it has to do with the laws that make sure your constitutional rights are not infringed upon, is what that basically boils down to. Case law, again, comes from precedents. Case law gathers from multiple cases from a given area and uses previous determinations made by area courts to act as binding rules that are to be upheld. Statute law is what we have. There are statutes, rules, regulations. The example that I gave, as I've mentioned before, I'm from Texas. The city of Austin has on its books that you cannot operate a handheld device while you are operating a vehicle, and that pertains to motor vehicle or bicycle. If you are in motion and a police officer sees your cell phone, your iPod, GPS, whatever, in your hand, it's a fine, first off. Repeat offenders, license revocation, jail time. Now, this goes for bicyclists too. If you are riding your bicycle and you pull out your iPod because you want to change the song, you're getting a ticket. It's that simple. And that's not necessarily how it goes everywhere else. Florida has don't text and drive, but they're not going to necessarily ding you because you're changing the song on the stereo or activating your GPS. Austin, Texas will. And the statutes vary from city to city. They can also vary from state to state. Let's see. Identify and give an example of ex post facto law. Well, ex post facto law. Ex post facto comes from out of the aftermath. It pertains to the Latin nullum crimen sine lege. It's the principle of legality. You can't criminalize an act or punish an act if it wasn't criminalized when the act happened. I found a case example of a gentleman named Marvin Pugh. Marvin Pugh was found guilty in 2010 of check kiting, loan fraud, and a handful of other things. He was tried, however, based on the guidelines that existed in 2010. His legal team asserted that he should not be tried under the 2010 guidelines, but rather the 1998 guidelines that were in effect when he committed his crimes in 1999 and 2000. Explain how the burden of proof relates to a criminal proceeding. This is sort of a tie-in to the how criminal and civil are different. Civil is just a preponderance of the evidence. It's a matter of majority. You can win a civil trial with 51%. Burden of proof in a criminal proceeding is not that easy. It is beyond a reasonable doubt. And that sort of sets up that you have to establish what a reasonable doubt is and what an unreasonable doubt is. A reasonable doubt would be a juror asking, well, how did that person rob a liquor store if they're on security camera at another store 50 miles away at the time the crime was being committed? That's a reasonable doubt. What's not a reasonable doubt is saying something to the effect of, well, maybe he was in the store because he saw a ghost break the window and he went in to see about more ghosts because he's interested in paranormal activity. It's not reasonable. And that's sort of how the burden of proof relates, is the prosecution has to present their case in such a way that 12 people, all who are going to have different levels of believability, accept what you're saying to them as this is how it had to have happened based on what we know. Explain and discuss the legal elements of crime. So, mens rea, actus reus, concurrence, and causation. Mens rea, as we all should know at this point, is your mental state, your intent. Actus reus is the guilty act in and of itself. The two together bring about your liability. Concurrence is those two things happening at the same time. Now, you can have the mens rea initially that leads to the actus reus, and that would still fall under concurrence. Causation is the harm that was created by a person's act. Would this have happened were it not for the actions of the person? And if I'm not mistaken, this is the last part. Identify and discuss the legal defenses in criminal law. Well, there are a few. There's immunity, and there's a few different forms of immunity. The main one that we're most aware of is diplomatic, due to agreements with other countries, the fact that technically we have dignitaries who work for embassies and things like that who are not technically U.S. citizens but do work here as benefactors to other nations. They're immune from our prosecutions. Mistake or ignorance of fact. We've all heard ignorance of the law is not a defense. There's some very finite wiggle room, but for the most part, ignorance of the law does not work. Case of mistake, the book gives the example of somebody who broke into a house because they thought it was abandoned. Doesn't change anything. You still broke into the house whether or not you thought somebody lived there. But a woman cashing a check that somebody wrote her that bounced because that she didn't know that it was going to bounce, that's not a crime. Writing a bad check is. Cashing a check that you had no knowledge was going to bounce is not. Intoxication. Intoxication's a hard one according to our text, because intoxication under most circumstances is involuntary, and because you did it to yourself, you're still responsible for what you do as a result of it. Involuntary intoxication or drugging is another form, but the requirements to prove it are a little harder. You have to prove that you were drugged against your will. You have to prove that you acted the way you did because of that, and you wouldn't have otherwise. Duress and necessity, we've gone over. Duress is acting or doing because you were kind of put into a situation where you didn't have a choice. Somebody points a gun at your mother and tells you, go in there and rob that store or I'm going to shoot her. And necessity is, the example that I used is a hostage situation. You have a hostage who shoots the kidnapper so everybody can escape. Under normal circumstances, you shoot somebody, there's going to be, a trial involved, but were it not for you shooting that person, there's the very real possibility that you and everyone else in that room might die. So the action has to outweigh the possible end result of more harm. That is a very brief overview of the whole of my paper. I'm going to go submit this paper now. I learned a lot in this class, actually, and as the time of this course has gone on, when I watch the news or see police incidents on TV, I have a greater understanding. I used to question some of the aspects of things, but now I have a greater understanding of them and don't find myself questioning so much as I'm going, what was the guy's intent? Or, what was he thinking? That, the understanding has been invaluable, and I've really enjoyed it. So that's it.